Sweet. Thank you, Zap, for the kind introduction. Thank you all for joining us. We are excited to have you here. I'm Andrew Goodwyn, and Holland Hendley is my partner. We run a law practice, Hendley and Goodwyn, very cleverly named. No, it's a little bit clever because, you know, Hendley and Goodwyn, you always end on a good win with us, you know what I mean? So we got a little bit of cleverness to us, but not too much. We leave that for the rest of the creatives. So today we're going to be talking about business-to-business contracts. But before I start presenting and share my screen here, I'm going to let Holland say hello.
Hey everybody, my name is Holland. Like Andrew said, I'm the other half of Hendley and Goodwyn. We run a practice here in Nashville. We love Nashville. It's been super great being here since late 2019. We've been weathering the pandemic alongside all you guys. I know it's been tough on everybody, but hopefully this workshop is helpful to you in trying to navigate the business-to-business space. And potentially anything that we talk about, you know, could be applicable to B2C space as well if you find yourself there. Anyways, yeah, let's dive in.
When he says we love Nashville, he really means we love the four walls of our apartment, because who's had time to go see anything these days? All right, so I'm going to share my screen here and we will get started. Okay. All right, can you guys all see this screen?
Looks good.
All right, so if you guys don't know, to be or not to be is a quote from Shakespeare's Hamlet. So this does not say Piglet, this is Hammy from Toy Story. It's Hamlet. All right, I'm hilarious, just acknowledge it and we'll move on. All right, to be or not to be, or yeah, business-to-business contracts. That's what we're gonna be talking about today. So why do I need a contract? At the bottom, you'll see a quote here that I feel like I'm repeating almost on a weekly basis now, but good faith and handshakes go as far as the money does not. That means you need to have contracts in place when you're putting out money for anything really, because, you know, people, they're always like, oh yeah, this is gonna be a great business. We'll go in together. It's all gonna be fine. And everything is usually fine when you're in that planning phase and just getting excited and everyone's excited. But then once money starts moving around, once money starts being a factor, all those good faith agreements that you guys made go out the window and it becomes a bitter fight, right? And so as lawyers, we always want to prepare for the worst and achieve the greatest. So business and commercial contracts are useful because they help keep both parties keep their promises, and not just ordinary promises, but these are promises that are going to bind you legally, okay? And so you guys also, please feel free to ask questions all throughout this. This is, you know, a time for you guys to talk to some lawyers and get some good general advice. So just chime in whenever you want. Now there's tons of things that can go into an agreement, right? But a lot of these are going to have, you know, a lot of contracts are going to have the base provisions. So when you're contracting with another party or when you're dealing with another business, there's going to be an exchange usually of payment for either services or goods. So getting the price out there and the term, the price, the payment, the term, all of these things are going to be important things to nail down when you're starting your business. So who's required to pay what, as well as when and how payment is going to be delivered. Are you guys going to be accepting deliver of payment via wire transfer or check? Is it going to be all up front? Is it going to be half up front? Is it going to be none up front? There's so many different ways you can contract this, but doing so just ensures that payment will happen on some sort of term, and that's a term that you and the other party has agreed to. And I think there might be a chat, so I should probably be looking at this at the same time.
Sorry, it was just me.
Oh, okay. Yes, drop questions in the chat. I now have it open. Term and termination. How long is this contract going to last? Are you guys entering into a 1-year agreement, or is it going to be more than that? Are you going to have options for renewal? And what's going to happen? What's going to happen if you trigger those options for renewal? Are you going to have additional addendums that are written in? You can just kind of prepare for everything. And when you're talking about termination, it doesn't mean like, oh, this is early termination, but this is like termination at all, whether it's early, whether it's happening at the right time. You just want to contract for this sort of stuff. And what happens if one party wants to leave the contract early? Are you just going to let them go for free? Are they going to have to buy out? I mean, there's so many variables, so it's stuff you want to keep in mind. And now this next one, service and deliverables, I really want to kind of hammer this home, because a lot of the times when people are writing out their contracts, it's like, okay, I'm paying $10,000 to this person for them to provide, let's say, accounting services. But you want to really flesh out, what does accounting services mean? And you want to put this in the contract, because if you just say accounting services, that's pretty general, right? And it leaves a lot of it up for interpretation. So when you really parse out what this person is going to be providing you, there's no room for like, oh, didn't we agree that you were going to provide this? And it's like, oh, well, this isn't actually covered. So you want to make sure you know exactly what you're paying for and exactly what you're getting for what you're paying for. And then also, contracts are just good to define the relationship. You want to know just what everyone's getting into. And I'm going to let Holland talk a little bit more about what else you'll find in some B2B contracts.
Yeah, I think to hammer home some of the points that Andrew raises from that last slide, defining the relationship, that's like a phrase we hear from like the dating world or like self-help books and stuff like that. But it really is important for contracts, and especially when you're doing business. I mean, a lot of business owners get concerned when they see contracts come across the table because they think, oh, we had verbal agreements on some certain things. So like, do we really need to get lawyers involved? Do we really need to write anything out? And it's not so much of looking at all of the nasty potential scenarios that come out. Yes, that is one thing that we do. We try to proactively address those issues that could happen. But the biggest thing is just defining who's doing what here and what is our relationship together, because the whole reason we're going into this agreement is because we want to both succeed. We want this to be mutually beneficial. We want both of our businesses at the end of the life of this deal, we want to come out ahead here. So I think the big thing to overall consider when you're entering into these contracts is, how are we going to define this relationship? So let's go on to some of the other things we're going to see in there. Now, the big thing, and this is becoming more and more prevalent, is just intellectual property rights, especially in a tech town like Nashville. A lot of people here, and a lot of you EC members, are coming up with products and services that honestly just blow my mind. I mean, I run a law firm, and I feel like what I do is it's rather straightforward. It's been done for like hundreds of years. So I don't really think of, the services I provide as really so spectacular, mind-blowing as some of the products and services you guys come up with. And the reason that's so important is because what you're doing is so special. So it's worth protecting, and it's worth trying to grow by using the mechanisms that the law gives you. So we want to use contract provisions to kind of carve out who's doing what, who's getting what, and what the relationship is, kind of, bringing back that idea of defining the relationship. So you can kind of see there, it's like, who's going to use the intellectual property and what are their rights? Can they go within and authorize somebody else down the line to use it? That's a great question to ask, and something that may be applicable for your business, but may not if you're in a different space. And then probably the biggest elephant in the room of all is ownership of intellectual property. If I am contracting out for services to create, let's say, something real basic, I need branding done for my company, or I need some marketing materials done for my company so I can really take this next quarter into a stride and try and grow my business further. Well, the question is, who owns that stuff? Is that going to be the independent contractor you engaged, or the independent business you engaged to do all that for you? Or did we have a carve out in your contract that says, yes, I own this, I have all right and title to use this, so on and so forth? There's a lot of legalese and stuff.
Just to kind of hit on that point, Holland, with intellectual property, when you have someone creating intellectual property for you, say it's some branding, the copyright ownership, when someone creates something, the ownership vests in them unless it's been previously contracted that it's going to, be a work for hire, or it's going to be assigned over in the future. So if Holland came to me and wanted me to design a logo and paid me $100, and I design the logo, if he doesn't contract with me, I technically still own the copyright for that logo, even though I've given him permission to use it, basically. So you really want to make sure in your contract to define it as like, this is work product that I'm creating for your business, and you'll own all right, title, and interest to it. And if you fail to do that in the beginning, and you need to kind of backtrack and take care of, maybe you got a logo from someone and you're like, oh, do I own the copyright here? If you didn't contract for it, the answer is no. And what you would do to get that back is do what is called a copyright assignment. And that's just another type of agreement that you can make, and that'll speak directly towards intellectual property rights and who owns them. So continue on.
Yeah, and that's a great point. I mean, the classic example we give a lot of the times in the legal space is the Nike swoosh. And it comes up a lot when we talk about trademarks, but everybody knows how iconic that branding is for Nike, and it's ubiquitous. I mean, you see it everywhere. But I mean, that was designed by a college student back in Oregon, forever ago. And so you can imagine when it came time to bargain over who owns that, that student had a lot of leverage. So yeah, you want to address these things proactively as much as possible and avoid the situation down the line where, because you didn't address something, it becomes prohibitively expensive or much more expensive.
By the way, that Nike swoosh, they ended up, settling for several millions of dollars because the student still technically owned the copyright. So that's kind of the value there, right?
Yeah, it's big. It's big. So take all that in mind. Intellectual property is becoming increasingly more important in contracts, and likely will be the same for your situation, regardless, kind of the industry or, market you're trying to cater to. Okay, so now let's move on to like confidentiality. This is a big one that I'm sure a lot of you guys have dealt with as well. Confidentiality agreements, NDAs, non-disclosures, they're everywhere now. But the big thing is how this is worked into your B2B contract. What information are you going to be obligated to kind of put a shield around, whether that's internally within your organization and also externally, who are your vendors and people you're working with that you need to make sure, because of a contract you have with another business, this information stays protected. This can often be really important if you're working in a space that has, trade secrets and specific methods or processes that are really unique to one business, and that's their main leverage in the market, is what they've come up with or what they've invented to give them a space and get them up ahead of their competitors. So confidentiality is going to be a huge one. And then you have things like notices. And this notice kind of applies a lot whenever you have an event that's been triggered in a contract. Say, you've gotten a year into a contract, and now it's the question of, well, do we want to exercise our option and enter into a second year? To do that, you'd likely send a notice to that other company. And a notice provision, sometimes they can be pretty standard, but sometimes they can be applicable for a range of situations like I just mentioned. And so you want to find out, who do I need to send official notice to, and what does the form of that need to look like? Because a lot of these will specify, this needs to be done this way. The classic example in the 80s and 90s was by fax. And, nowadays nobody has a fax machine. So hopefully your notice provisions don't call for facsimile transmission or anything like that. But if they do, work that out, get it ironed out and everything, update it a little bit for.
It's fine to have it in there if it also includes, other types of ways to achieve notice.
Yeah.
Before Holland moves on here, I'm going to answer a question from the chat. Gable Eden asks, my operating agreement states the company owns the product and has ownership of other products created for the company to sell. The intellectual property should go into the vendor agreements as well. So Gable, your operating agreement is an agreement that is binding on you and the people in your organization. It doesn't, none of your vendors signed on to that agreement. So that's going to dictate the way you guys do things. So if you created, as a partner for your company, created some materials, it would be owned by the company because that's how you've written your operating agreement. However, if you're contracting with a separate vendor, they're not bound to the terms of your operating agreement. They never signed on to it. So whatever contract you have between yourself and that vendor is going to have all the things we're talking about: pricing, term, intellectual property, notice. It'll be a whole new contract. It might have some similar elements of the operating agreement, but remember that operating agreement is an internal document, whereas your vendor agreement is going to be an external document. So.
Definitely, yeah. I mean, that's a great point to
I
raise.
think I should have been a little bit more clear. What I was saying was these exact same items that I'm seeing here in the B2B agreements are some of the line items that I have in my operating agreement, but they should be incorporated with my B2B agreements, outlining, for instance, you have my product, I'm giving you my product to sell, but you cannot use a third party. You can't put it on your website and sell it. You can only sell it from your establishment, things of that nature, correct?
Yeah, precisely. That's in that agreement with that particular business is where you'll want to identify, just like you mentioned, all the things and the restrictions you want to put on that other party. And your operating agreement doesn't really do that. Yeah, you might have similar provisions in both, but regardless, the situation, you want to kind of carve it out for each party that you're entering into a contract with.
Just remember who are the signing parties to that agreement. And if your vendor hasn't signed on to your operating agreement, since that's an internal facing document, they're not going to be bound to any of the provisions in there. So you want to make sure that, of course, your operating agreement is sound for any internal stuff, but for external transactions, you're going to have a different contract, which is, like Holland said, going to have similar provisions, but they're going to be binding on newer parties, different parties, including you and the party you contract with, if that makes sense.
So, and then, going back to our slides here, we have the second to last bullet point, which is choice of law and venue. And this is something you'll kind of see in nearly every agreement, which is, if we have a dispute, what's going to be the applicable law? What are going to be the rules of the game? How are we going to go about trying to resolve this, and where are we going to resolve it? Now, this is important if you're doing business with people who are in different localities, which most people are these days. The economy isn't so regional or cabined off. Sometimes it is. You're just doing business with two people local, so you don't even have to worry about this. But sometimes you're doing business with somebody, who's on the other side of who's on the West Coast or the East Coast or somewhere in the middle of the country, or even possibly internationally. And so having a choice of law and venue provision is big, because you want to kind of lay the groundwork and try and find you a venue that's not going to be prohibitively expensive for you to litigate in the event that there is a dispute. If you can kind of stay on your home turf, so to speak, then that's going to be really important. And then there's so much more. I mean, we could talk for hours about all the different things that can go in a contract, and it really just depends upon the relationship of the parties and knowing your business and what you're trying to achieve. I mean, we could rattle things off like survival clauses and payment
force majeure
terms.
clause.
Yeah, all of that stuff. Really, the big point is thinking about and understanding your business. What are you trying to achieve by entering into this contract? And what are you trying to come out on the other side? Andrew uses a phrase a lot, which is, be outcome oriented. And so I think that's really helpful to think about. And I'll let him kind of talk about that.
Yeah, so that actually is some advice that I got from Shawnee Dowell, who is the founder of Posset. And if you guys aren't familiar with her, she's an incredible founder, and she has a ton of wisdom. And so she told that to my girlfriend, actually, who works for Posset. My girlfriend relayed it to me. And that was kind of my 2020 theme, was be outcome oriented. And it really turned into not just like a mantra in my life, but a mantra in business, to help people kind of understand, like, okay, I'm getting into this contract, but to what end, right? So if the outcome you want is to sell 10,000 widgets, and you contract with someone you want to sell 10,000 widgets. So what steps do you have to take to get there? And a contract is part of that, right? So being outcome oriented helps, like, don't worry about the steps right away. Think like, okay, what do I want to achieve? And then once you've understood what you want to achieve, what steps do I have to take to get all the way there? So Gable asked also, how are we as laymen to determine what goes or should be included in a business-to-business contract? And that's a great question, because attorneys think of us as, imagine life is a board game, but only some people have a copy of the rule book. Or maybe we all have a copy of the rule book, but only some people have the time to read the rule book. So attorneys basically have the rule book. So while as a layman, you definitely want to be able to understand what's in your contract, there's going to be more complex parts of a contract that are just going to, is the cost or the time it's going to take you to learn about it, is that going to be worth it, or is your time better spent elsewhere? So you always want to have an attorney review a contract, especially when there's a decent amount of money that's on the line, right? You never want anything to go bad, but the reality of life is that things go bad, and 2020 is a testament to that, right? So there are tons of resources online to help you understand what goes in a contract. This whole series should help you understand what should be in a contract, as well as we have a blog series where we write all sorts of helpful stuff. So this whole presentation is based off of a series, an ongoing series that Holland has been writing about what goes into agreements. And we have lots of different blogs, like we have one that talks about what goes into a licensing agreement. What are we generally looking for? But as far as just like what should be in there, we really kind of hit on a lot of the main points, right? Pricing and payment, term, how long is this going to last? Service and deliverables, what am I getting for the exchange of payment? Who's giving what? Who owns what IP rights? So there are tons of online resources, and I mean, Google is always your friend. It's always where I start personally, not Bing, unfortunately. Because usually there's tons of law firms out there writing blogs, and you can almost always find at least a good primer to your question before you pick up the phone and call an attorney and say like, hey, want to explain this a little bit more to me. So there's always tons of resources you can find, whether it's a presentation like this or a blog from our website or another law firm website. Just making sure it's a trusted resource. Kaylee Malloy asks, talk a little bit about the distinction between transactional contracts, 1 or 2 deals to buy and sell, and strategic contracts. We're going to be servicing you for the next 2 years. So let's see, a distinction between those. I mean, one thing could be one is a little bit more ambiguous, right? A strategic contract might be a little bit more ambiguous. Transactional contract might be like, hey, I need to buy 10,000 widgets. How can I complete this? Okay, pay us $5,000. And for the $5,000, we'll deliver the 10,000 widgets on this specific date, right? That's just one very simple transactional contract. And then you have more strategic contracts, which are like, okay, those are probably going to be more likely when you're purchasing services and things like that, as opposed to goods. So a strategic contract, say, we're going to be entering into this contract, and you're going to, I'm going to pay you this amount, and you're going to provide us with this strategic service, whether that's helping us understand the market or helping us, acquire good manufacturers and things like that. And what's really important about those strategic contracts is making sure, here, let me go back to the last slide, your deliverables, making sure those are really hammered out. Because if you don't hammer those out, and you have this long contract and you haven't really defined what they're supposed to be providing, then you've kind of lost some of the strategy in your strategic contract. So you really want to make sure you're defining, all right, we're paying you this. What are you guys truly delivering to us throughout this lifetime? So I hope that answers your question. I'm not sure if I understood it totally. And can a purchase order work in lieu of a contract for a transactional exchange as long as the basics are covered? So yes, so a contract is just 2 mutual meeting of the minds in exchange for goods or services with consideration. So even a handshake or even an oral agreement technically has legally binding effects. The problem is, say me and Holland entered into a handshake agreement, and then a dispute arises, a few months later. How do we resolve this dispute? We have no contract that we can look at to determine what happens when a dispute arises. And if we wanted to take it before a judge, we would have to say, okay, we agreed on these terms. But it's just harder to prove, right? You might have to bring in additional witnesses. You basically, by doing an oral contract as opposed to a written one, you're running the risk of high court costs and court fees if you end up having to litigate, just because there's so much more room for ambiguity, right? These written contracts really help say, like, this is what's happening. And if something goes afoul, this is how you remedy it. So you prepare for the worst case scenario, even though you're hoping for the best.
Yeah, and I will add on to what Andrew says is, like, purchase orders are great because they streamline everything you need to do and they make your life a little bit easier. You can just say, hey, please send 10,000 widgets. I agree to buy this many at this price. And then your supplier may send back a similar purchase order that says, okay, we'll send 10,000 widgets for that price. But then the problem is there may be additional terms on their acceptance of that purchase order. And this happens a lot when people use pre-printed forms, and really, especially in the manufacturing space. The problem is you have these additional terms that aren't on one party's pre-printed form. So the question is, do those get accepted? And the law takes a pretty nuanced approach to it. The general rule is kind of like, if you don't object to those terms and they don't really alter the deal significantly, then yeah, you're going to be bound by that supplier's acceptance. And say the supplier says, well, if there's a dispute, then you agree to binding arbitration over here in Kenosha, Washington, or somewhere like that, then you may very well be bound by that. So while pre-printed, just purchase orders are great, they can come back to bite you. And overall, just the idea is to, thinking back at the beginning of the presentation, understanding your business and defining the relationship. Keep that in mind. As a business owner and somebody running things, you might have an idea of, like, okay, I know how I want pricing to look. I know how I want the deliverables and the performance to look. But I need to bring in an attorney to help me out with all of the other things that I'm just not thinking about. And that's understandable because you're doing a lot of things that attorneys aren't thinking about. You're running your business, which takes a lot of know-how and skill. And then you have these advisors in your team that you bring in to do other things. You have people who you bring in to do marketing, accounting, legal, what have you. So really, it's all about using your team to make sure every contract is most effective for you. And it just so happens that when contracts and legal are involved, lawyers, that's what we're here for.
Also, just if you are only going to go with the purchase order, just make sure you read the whole thing, because they're probably going to have some T's and C's, some terms and conditions at the bottom, and those are going to be binding for you. So just make sure you understand those. And just like just to give one thing, just one example of like something you could easily miss as a layman looking at a contract that you may just not know, right? For attorneys, this is general knowledge and commonly known, but for non-attorneys, it might not be. So, and that is in a contract, if you see a term that is capitalized, that means that it is a defined term. So if it is a capitalized word, in the middle of a sentence, you're like, why is this capitalized? That means that that term has been defined to mean something else, and that it's going to mean that every time it's used throughout the agreement. So if you see, this contract for widgets, and then in parentheses, it'll say the agreement with a capital agreement. So every time agreement is used, capitalized in that contract, that's referring to the four corners of that agreement. However, if the word agreement is used and it's not capitalized, it's not referring to the actual contract. It's referring to, just agreements in the normal understanding of that word. So that's just like one little thing that attorneys know, and that's just part of the practice that a layman might not know. Always know what those defined terms are meaning, because it could really change the meaning of that sentence beyond what it would mean to a layman. So that's just like one nugget of like random attorney knowledge that is not commonly known, but is helpful to know. So look out for those defined terms and make sure that they mean what they mean. It's often means you got to pull the agreement up on two screens and start searching in one document for those defined terms and just comparing and making sure everything lines up. And one thing I want to talk about, guys, so I am so often asked these days for a quote simple boilerplate agreement. And is my simple boilerplate agreement going to work, or is this something you can work off? There are rare instances where these are fine, right? But the thing is, those are boilerplate. They were written to really just be a starting point and to apply generally. But you guys all know your business is unique. So you can't really trust a contract that's not going to be unique to your business and unique to your needs. So boilerplate agreements sometimes are okay. And there are some rare instances where they'll really work for you. But in my opinion, boilerplate agreements are just a dangerous way to go. It's a short-term solution or a quick, cheap solution to a long-term and serious issue. When you're dealing with your business, it sucks to really have to, put all the costs in legal and just the cost of running a business. But if you're using a boilerplate contract, it might seem like the perfect contract at the time, but every contract is perfect until it gets litigated, until there's a dispute. So you really want to make sure you're working with an attorney to go through these contracts with you and make sure that it's uniquely tailored to your business.
Yeah, and I'll add on to what Andrew said before we address, I think, the next question in the chat, is that your business is unique, just like Andrew said. And working with an attorney who can talk to you about, okay, how do you want pricing and performance to go into this, is you can start to get creative and find something that's really mutually beneficial for both people. For example, let's say you have some sort of management agreement, and while you're providing the capital and kind of the logistics to get something done, you have another company who's coming in and taking over all the management and day-to-day operations. Well, in that arrangement, the payment, rather than a flat fee or a monthly rolling amount, it might be more beneficial to just go with a cost plus formula and some sort of percentage of, gross or net revenue, and go from there. And then you might have another agreement where you're licensing something out, whether it's your tech, software, what have you. And to kind of achieve your goal there, you're gonna set what we call like goalposts. And let's say, I'm gonna license this out. And if you are able to drive, you being the other business you're working with, or if you're able to drive 100,000 in revenue, then I'll give you 2% of that. But if you're able to drive 500,000 in revenue, I'll give you 5% of that, and kind of incentivize better performance of that other business going out and doing better under the contract, and then that benefits the both of you. You're seeing more revenue, but so are they. So they're incentivized to keep working harder and doing everything they can to make this deal as good as possible. And so that's like a really basic example of how you can use different drafting techniques to try and achieve your goals and grow even more.
All right, so we got a question. If you had to write a book called Johnny Starts a Business, what would be the top 5 contracts you would tell Johnny to have? We already know that one would be IP. So this is a good question, and it can vary depending on the type of business you're running. But I will say, generally, every business you want to start with an operating agreement, especially if you have more than one founding partner in this business. And this is going to dictate all the internal policies of the company. And it's going to talk about pretty much everything that's going to happen, how you're going to split up profits and losses with your partners, who's going to be the tax representative for the IRS, just a variety of things that agreement is going to cover. And you usually want to do that, and you can usually get that as a package when you form your business entity. But that is something you definitely want. It's going to account for, what if one of the founders wants to exit the partnership? And it's going to account for, what if someone gets hit by a bus and dies? What happens to their partnership, right? These are the things that you hope that they're remote possibilities, but guys, life is crazy. So you just have to think about them, or the lawyers have to think about them, and you have to be like, oh, I didn't think of that. So one would be an operating agreement. And Holland, if you think of other good ones, just chime in.
Yeah, I'll pop in and say a non-disclosure agreement. I mean, the
Well,
reason they're so common is because you want to protect your specific product, service, or trade secrets that you've come up with that you feel like give you a leg up compared to your competitors. And you want to define that protection both, internally, what sort of safeguards do I need within my own business to protect that information? But what sort of safeguards do my vendors or suppliers or distributors, everybody who's at arm's length from you, what do they need in their business to make sure my information isn't getting leaked anywhere? So yeah, I'd say non-disclosure agreement is big, and those can often be quite simple.
Yeah, I will say, of course, depending on the type of business, but if you have a website, you're going to want to get a privacy policy and a terms of use or terms and conditions. Now, just to kind of hit on that a little bit, a privacy policy is a document that is internal, right? Well, external facing. So people see it and people read it, but it really talks about the policies your company has when it comes to collecting personally identifiable information. And that is something that's a legal requirement if you're collecting email addresses, phone numbers, any sort of personally identifiable information. A privacy policy is a legal requirement. The terms of use, that's different. That's not a legal requirement. That is a contract between you and the end user. So the person that's on your website, when they agree or when they surf your website, usually they're agreeing to the terms of your website. So say your website has a chat feature. The terms of use is going to determine like no explicit language allowed on our website. Think about Donald Trump being banned from Twitter, right? How did they effectuate that? Well, he violated their terms of service, which was an agreement that he agreed to by using the platform. So when you're doing a website, those are some good agreements to have. And then I will say a services agreement. You're likely providing goods or services as a business, and you're contracting with other people. So you want to have an agreement between you guys. Now, this one, you don't have to you want to avoid getting the gear, right? So you don't want to get stuff you don't need. You want to make sure the stuff you have has a good legal operative effect and that it's, a positive decision for your business. You don't want to go out and just spend thousands of dollars on contracts that you might not actually need. So it's definitely a kind of like as you need them type of thing. So if you're not doing services and you're not offering services for another 6 months, then you don't want to draft that contract because the things that you're going to find within that contract are likely going to change in the next 6 months of your business before you actually utilize that agreement. So be prepared for the future, but don't over prepare because it can end up being kind of a less cost efficient way of going about it. So just remember that there's no getting rich quick and there's no quick start to anything really. It's tackle these things as they go. If you have the budget to prepare for them further in advance, do that. But just make sure you're preparing and you're not getting agreements just for the sake of getting agreements. And remember, be outcome oriented. What is the outcome I want? How can an agreement help effectuate that outcome? And that's when you want to start thinking about that. I don't know if I actually hit 5 agreements, but those are all really useful agreements. And I'm sure Johnny is going to have a successful business, certainly.
Yeah, I agree with Andrew. I think it's a great question, Rhonda. In as far as general agreements, the ones we kind of highlighted are great. But like Andrew said, there is no really one size fits all approach. Yeah, there's going to be certain agreements that everybody needs, like the privacy policy, terms of service, operating agreement, things like that. But then maybe one other one I would throw in there is probably just employment agreements, especially if you have regular
employment or independent contractor.
Yeah, or independent contractors. You're going to want something kind of defining that relationship and what's expected of that employee or independent contractor, and then what's expected of your business as well. Employment laws are very complex, and it's extremely important to be proactive about that because for good reason, lots of employees have been abused over the history of, just labor law in general. And so a lot of those statutes are drafted to be very employee friendly to prohibit bad practices. So yeah, that's probably another one I'd throw in there as the general bucket for Johnny's business.
Rhonda asks, logo was created by one person, but included in mark for trademark. Who owns it? I'm not sure I understand the question entirely. So logo was created by one person, but included in the mark for trademark. Maybe try rephrasing that question for me, Rhonda. And while you think about that, I'll answer this question from Mark. Outside of a basic NDA, what types of stipulations would you include in an agreement for external advisory board members? That is somewhat of a specific question. It might be a little bit too specific to really be able to answer that. So yeah, you may want to try and come up with something a little bit more general, because we can't really give specific legal advice since we don't have an official attorney-client relationship. So yeah, that might be a little bit too specific.
Yeah. I think if I were speaking generally, thinking about what I typically see in external, advisory agreements, one thing I commonly see in those types of deals or agreements is that somebody's going to commit a certain amount of time to make sure that, if you're agreeing to be on this role, then you are agreeing to be all in. You're not going to be halfway there. You're going to take the time and the effort it takes to commit to this position and actually provide substantive advisory services. That's something I generally see in those. And, if you search, just public companies and their board advisory agreements, you see that all across the SEC filings that those companies make to reflect, they have these board members in their company providing advisory services. And typically every single one of those agreements says, you agree to provide, a certain amount of time and effort it's necessary to fulfill the duties and responsibilities of this role.
I'm going to take a stab at this question from Rhonda and just kind of, okay, logo included in company trademark. So a trademark, I'm just going to try and talk basics here, and hopefully this information will answer that question. But a trademark is a source identifier. So when you see a trademark, that tells the consumer where that good or service is coming from. If you had someone create a logo for you, the creation of that logo, the actual artist creation, is a copyright issue. So the mark that they're creating is a copyright that's vesting when they draw that mark. And if there was no deal in place that talks about who owns the copyright, then they would technically still have it. If sorry, I'm trying to understand this question here. The logo is included in the company trademark. So this might be like, have you defined what work product is? So if I was a company and I gave a designer some assets from my company, then I would want to be explicit that any work product created by this artist that includes my work product, if my assets that they used are included in the design, I own those and I've retained the rights to those, and that's been defined in the agreement with that designer, that, hey, any previous intellectual property that you include in this mark is owned by us and you have permission to use it for this mark, right? And then you would want to have that done as a work for hire so that the copyright that they make vests immediately in you, the owner of the business. I hope that answers the question. I was a little confused by the question, but hopefully that at least gives you a little bit of info there.
Yeah, I think one thing we can kind of recall back is if you think about the Nike swoosh, so that is a trademarked thing, that swoosh. However, the design of it and the actual, creative effort is not a trademark. It falls under copyright law. So it's a different area of the law. It is still intellectual property law, but it's different. And generally speaking, the creator is the person who is entitled ownership of that. So, I mean, that's kind of the thing to think about, is when there are creative individuals that your company no matter what your company does, if you're bringing them on to create inventions, new processes, or methods of manufacturing or design, or whether it's just straight marketing materials, then yeah, those things are going to be different. And so
I have a chart I'm going to pull up here from one of our last presentations. Welcome to the design of our business, as soon as I can find it. But I do have a slide that I think would be pretty helpful if I can manage to find it. Just give me a second here.
I think we have a recorded video about everything you need to know about trademarks, and we can probably just drop that in the Slack channel, the EC Slack channel. Oh yeah, you found it. Oh, Rhonda answered the question. Oh, great. Cool.
Okay, you guys can see, everything you need to know about trademarks here. So this slide, I think, will kind of help just give a little information, and I'll jump back to that other slide in a second here. But a trademark protects your brand, prevents others from claiming the mark as the source of their stuff. A copyright protects your creative work, prevents others from using your art, music, books, performance, and a patent protects your invention. So those are just kind of some basic differences between the three areas of intellectual property. So I'm going to go back to this original one. Also, just business advice that's not related to the law. Canva is a great tool to use if you're marketing, if you're bootstrapping your company. Hendley and Goodwyn, we are a bootstrapper. Every piece of marketing material, everything you see is done by either myself or Holland. We don't have any social media interns or anything. So Canva is a super awesome resource to just really help you create good-looking, well, aside from this page, ignore that, good-looking presentations, and they're pretty easy to work with. So I'm just going to run back here. Yeah, those are just kind of some, sorry, my cat is like all over the place here. Yeah, so any more questions, I guess, here? When it comes to intellectual property, this is from Elmira. When it comes to IP, how do you define who owns the recording of a speech or music performance you give to a company? Any specific stipulations? Yeah, so this is a great question. So let's say you're giving a speech. You own the copyright in that speech unless it has been contracted otherwise. Unless so say a company hires you and in their agreement they say, we want you to give a speech. However, the speech that you write is going to be done as a work for hire, and the copyright is going to immediately vest in us, the company, as opposed to vesting in you personally. So if there's nothing like that, if you write the speech, as soon as you put pen to paper, type to word, that's your copyright. The copyright is vested. Now there's a difference, and we won't go into it here, but there's a difference between a copyright being vested in you and being registered with the U.S. Copyright Office. And that's, a whole different presentation. But as far as who owns that recording or music performance, that's going to be you unless it has been contracted differently. And Holland, I think, would agree with that as well. Yeah. I hope that clears up that. But as you'll see, a lot of the questions you guys have kind of point to how these B2B contracts are so important, because these are the contracts that are going to define all of these questions. Because you could own the copyright, but if it's contracted differently, you might not. And that's the type of stuff that can go in this contract. So they're going to talk about everything. The whole relationship between the two of you guys is going to hopefully be spoken to, and these kinds of questions will be spoken to. And when you work with an attorney, they're going to, at least we are, going to help you understand why things are in a contract. I don't know if you guys watch Portlandia, but there's a great sketch on there about when they're going camping and they spend the whole time getting the gear, and then I don't think they end up going camping. So we kind of talk about a lot when we're drafting contracts. We're like, okay, do we want this specific provision to be in this contract? And then we're like, okay, well, are we doing this because it's a get the gear and we think this provision should need to be in there, or does it actually have a legal operative effect that's going to be important for this person's business? So you want to make sure you're not just getting the gear, but making sure you understand, why is this in my contract? What kind of legal effect is it going to have in this relationship I'm entering? So that is one of the important things about contracts, is you can contract for all sorts of things, and you can have all sorts of provisions that are going to speak to different types of scenarios. But you want to make sure you're not just getting the gear and throwing stuff in there for the sake of having it in there, but because it's helpful in achieving an outcome specific to your business. Any other questions?
I completely agree. I think kind of this last slide kind of serves home a lot of the points that we raised initially, and it's all about thinking about that relationship, how you can advance that relationship, and also just have something to fall back on in the event that some dispute does end up boiling over. I mean, we never want disputes to happen, but as Andrew's mentioned, life happens, life is difficult, and things you don't foresee just pop up and arise. And so it's important to try and define as much as you can so that there's not all this ambiguity surrounding what happens here, what happens there. And we've kind of tried to foresee some of these things and draft around it, and really make sure that the road isn't bumpy. It's smooth sailing from here.
Now we have about 5 minutes, so if anyone has questions, we have gotten to our final slide. Just I'm going to throw out there, we do free consultations. So if you guys have more specific questions, always feel free to just pick up the phone and call us. Or if you just want to learn a little bit, we have a blog that we contribute to. It's all written by either myself or Holland. So it's not coming from anywhere else. It's coming directly from attorneys writing these. So there's a lot of good info on there. On TikTok, I don't know if any of you guys are on there, but if you are, I do a segment called Legal Tips and Skateboard Tricks, where I go do a skateboard trick and then I give a little legal tip. Guys, when I say that marketing materials for law firms are boring, I mean it. It is really tough to come up with engaging and exciting content. So that's what I'm going for with these legal tips and skateboard tricks, just trying to do something that can help make this not so excruciatingly boring. Because I get it, right? We're the people with the rule book. We don't exactly have the most exciting materials, but unfortunately, they are the rules that govern all of us. So while we try to keep it exciting, it's hard to do so. But please always feel free to reach out to us, and we always answer. You can reach out on Twitter, TikTok, Instagram, email, phone number, Discord. I mean, literally everywhere. I have probably some disorder that causes me to not allow myself to have any sort of notifications anywhere. So it's always going to get answered. With that, Zap, take it away.
Hey guys, are we ready? Sorry, I was intern's first day, always exciting. That's all. I'll send out the recording of this. The humor was impeccable. Thank you everyone for joining us. Thank you, Andrew and Holland, for your world of expertise. And I will share some more items with everyone.
Yeah, you guys, if you ever need an entertainment or business attorney or IP attorney, hit me up.
Let's go. Legal tips and skateboard tricks.
Thanks,
Bye,
everybody.
guys.
Yeah, search, I'll post in the chat. At Lil Esquire on TikTok. See you guys.
Bye.